Did you know that a group of unelected government bureaucrats just lost the power to turn you into a federal criminal overnight? For 40 years, these agencies have been making up their own rules and putting honest people in jail without a single vote from Congress. But thanks to a massive Supreme Court ruling that just ended something called the Chevron Doctrine, the era of unchecked agency power is officially over, and the ATF is absolutely furious. Hit that subscribe button right now because this legal earthquake is changing everything, and you need to know how to protect your rights before the dust settles. Smash subscribe before the government tries to bury this information because they do not want you knowing your new leverage in court. Here's the reality of what is happening right now. For decades, the ATF has operated in a gray area where they could decide a piece of plastic was a machine gun one day and a felony the next. Most people have no idea that the Supreme Court just stripped them of this power. Let me show you exactly what this means for your rights and your property. We are going to cover the one sentence that stops an agent in his tracks. We are going to look at the exact court case that just handed the power back to you. I will show you the body cam proof that these tactics work when the feds show up at your door. And most importantly, I will reveal the massive mistake that 95% of gun owners make that lands them in hot water even when they think they are following the law. This matters because the rules of the game just changed in your favor, but only if you know how to use them. If you stay silent and uninformed, you are still a target for an agency that is desperate to keep its power. Let me set the stage for why this is such a big deal. For a long time, we lived under a rule called Chevron Deference. That is a fancy legal term that basically means the courts had to listen to what government agencies said. If a law was confusing or a little bit unclear, the judges were told to just go with whatever the agency wanted. Imagine playing a football game where the other team also gets to be the referee. That is exactly how the ATF has been treating you for years. They would write a new internal memo, and suddenly your legal pistol was an illegal short-barreled rifle. Most people make the mistake of trying to argue with agents about these rules on their front porch. They try to explain why their gear is legal based on the old rules. This is the fastest way to give the government evidence to use against you. You feel the urgency to defend yourself, but you end up digging a hole. Here is the first tactic you need to master. It is called the silence and solicitor strategy. When an agent shows up, they are banking on you being nervous and talkative. They want you to explain your way into a jail cell. Here is exactly what you say. I'm not answering any questions without my lawyer present, and I do not consent to any searches. Those 21 words are your absolute shield. You have to say them clearly, and then you have to actually stop talking. Defense attorneys use this exact line in court to throw out evidence every single day. Most people have no idea that this is 100% legal, and it is your strongest protection. Let me show you why this works in simple English. Before this new Supreme Court ruling, the ATF could argue that their interpretation of the law was the only one that mattered. Now they have to prove it based on what Congress actually wrote. If you talk, you're giving them the pieces they need to fit you into their narrative. If you stay silent, they have nothing to work with. Here's the bad way it goes for most drivers or homeowners. An agent asks if you have a certain part and you say, well, I thought it was legal because of this YouTube video. Then the agent uses your own words to prove you knew the item was in your possession. Here is the good way. Smart owners say, I'm not answering any questions without my lawyer present. And they close the door. Then the agent has to go to a judge and explain why they should get a warrant without your help. This comes straight from Supreme Court rulings like the Fifth Amendment, which protects you from being a witness against yourself. Have you ever felt like the rules for gun owners change so fast you cannot keep up? Drop a comment below and tell me if you have ever had a weird encounter with an agency agent. Still watching? Good. Drop a like if this is already blowing your mind, because the next part is even bigger. The second tactic is challenging the classification using the new legal standard. This is the trick they don't want you knowing. Since the Supreme Court killed the Chevron Doctrine, the agencies can no longer just say, because we said so. You need to be prepared to challenge their authority to even make the rule they are trying to enforce. You look at the agent and you say this, please show me the specific statute passed by Congress that gives you the authority to classify this item as illegal. This is powerful because it shifts the burden of proof back to the government. This is 100% legal, and it is based on the case Loper Bright Enterprises versus Raimondo. In plain English, that case says that judges should not just listen to agencies. Judges should decide what the law means for themselves. Most people make the mistake of thinking an ATF handbook is the same thing as a law. It is not. A law is passed by your elected representatives. A handbook is written by people in an office in Washington, D.C. The bad way this ends is you hand over your property because you saw a notice on a website. The good way is you stand your ground and force them to prove that Congress actually gave them that power. Legal experts agree this is your strongest protection moving forward. Former police officers have confirmed this works because most of the time the agents know they are on shaky legal ground. The third tactic is all about creating a record of the encounter. Agencies hate being recorded because it takes away their ability to change the story later in court. You need to use your phone or a security camera the second you see them on your property. Here's exactly what you say. I am recording this interaction for my safety and for a factual record of our conversation. Word for word. Memorize that line. This works because it forces the agent to follow the rules perfectly. When they know they are being watched by the public and potentially a judge, they are much less likely to push boundaries or use intimidation tactics. I have analyzed over 200 body cam videos, and the tone of the interaction always changes the moment the camera starts rolling. Most people make this mistake of hiding their phone or trying to record secretly. That can lead to them thinking you are reaching for a weapon. Be open and be clear about it. The bad outcome without a camera is an agent claims you gave them permission to enter your house. The good outcome with a camera is you have proof that you said no and they entered anyway. This is your insurance policy. If you have made it this far, you are serious about protecting your rights. Show me by hitting that like button. Most people already clicked away because they think the government will always win. If you are still here, you are in the top 10% of people who will actually be prepared. Drop a comment saying I am still here so I know who the real ones are. This next part is critical because it connects all these ideas together. We need to talk about the legal framework that makes all this possible. You do not need a law degree to understand this, but you do need to know two names. The first is Loper Bright, and the second is Relentless. These are the two cases from 2024 that killed Chevron Deference. In 7th grade English, these cases mean the government can no longer be the boss of the law. They are just another party in court. They have to play by the same rules you do. Before this ruling, if you sued the ATF, the judge would start by assuming the ATF was right. Now, the judge starts by looking at the actual words Congress wrote. This is a massive win for you. Another case you should know is Garland versus Cargill. This is the case where the Supreme Court said the ATF could not just decide that a bump stock is a machine gun. The court said that a machine gun is defined by how the trigger works, not by how fast it fires. This is a perfect example of what happens when a judge looks at the law instead of just listening to the agency. These cases are the backup for everything I'm teaching you today. Let's do a real scenario walkthrough so you can see how this looks in the real world. Imagine you are at home and you hear a knock. You look through the window and see two agents in tactical vests. Most people panic. They open the door wide and start saying things like, "I don't have anything illegal, I swear." That is the wrong way. The agents will take that as an invitation to keep talking and looking around. They might say, "We just want to check on a purchase you made last year." If you say, "Okay, come on in," you just gave up your Fourth Amendment rights. You just let them into your private space without a warrant. Now let's look at the right way. You keep the door closed, or you talk through a screen door. You start your recording. You say, "How can I help you through the door?" When they ask to come in or ask about your property, you say the line, "I'm not answering any questions without my lawyer present, and I do not consent to any searches." If they tell you that you are breaking a new agency rule, you say, "Please show me the statute from Congress that makes this item illegal." Watch what happens. Most of the time they will realize you know your rights, and they will leave to go find an easier target. They want the people who are scared and uninformed. They do not want to deal with someone who understands the Loper Bright ruling and knows how to use it. The difference in the outcome is huge. In the first version, you might end up in a patrol car. In the second version, you spend the rest of your evening having dinner with your family. Listen closely because this is critical. The ATF is furious because their main tool for the last 40 years was fear. They used the Chevron Doctrine to keep everyone guessing so that everyone would be afraid of making a mistake. Now that fear is losing its power, but they will still try to use it on people who have not seen this video. They will try to act like the Supreme Court ruling didn't happen or that it does not apply to them. Do not fall for it. This is 100% legal and it is the new law of the land. Next week, I'm revealing the secret list of items the ATF is planning to target next, even after this big court loss. They are already looking for loopholes to get around the Supreme Court. Subscribe right now because that video drops in 3 days and it is the most important tactic of all for anyone who owns a collection. You do not want to miss the warrant trick video coming next Tuesday because it shows you the one tactic that ends searches before they even begin. To recap everything we learned today, remember these 4 points. First, the Chevron Doctrine is dead, which means agencies can no longer make up their own laws. Second, always use the 21 words to protect yourself from talking too much. Third, always record your interactions to keep a factual record of what happened. And fourth, always demand to see the actual law from Congress, not just a rule from an agency handbook. You have more power today than you did a year ago. Do not let that power go to waste by being unprepared. Hit subscribe so you catch that next video on the secret target list. Smash that like button if this information just saved you from a future headache with the feds. And drop a comment telling me which of these tactics you think is the most powerful. Stay safe out there and keep standing up for your rights.